All right, guys, get your final exam review out. And also go to Appendix A in your textbook. So we're going to kind of kill two birds with one stone. And this is the way I teach this section anyhow. But it's a good way to save some time. So if you've got your final exam review out, and in the state section of your final exam review, you see Appendix A, 12 questions. Everybody good to go? Your final exam review, the guideline to the course, the guideline to the test. That I gave you about the first day or so here, stapled together. All right, let's look at the first set of questions. You've got 12 questions under Appendix A on your final exam. Now, everyone, I do want to mention to you that these questions do get a little more detailed. Not saying that they all will be, but you do need to know the fine points. And when you finish here and apply for your to the Real Estate Commission and sit for the state exam, the state part of the exam is very, very detailed and very involved. So even when you pass this course, guys, you need to hit the books until you pass the state exam. And from what I'm hearing, I would study the state portion really hard. So what that means is, in your application section of Appendix A, there is an outline of what to look at for the state exam. And I'll just tell you the page one more time. We're not going to go there right now, but if you just hold your place, it's page 659, and it'll tell you exactly what to look for the state part of the state exam. It wouldn't hurt to come look at some of this before your exam here, but I do have bulleted on your exam review some of the areas that you're going to be tested on. So it's real detailed, and so preparing for your final for Monday, I would go back, even if you've read Appendix A, I would go back and read it again. And the part that I'm talking about reading begins on 6:15 and it goes to 6:36. So that's not a ton of reading, but I would read it slowly, and I would make sure I'm reading line by line, because you really need to know the fine points. Most students who don't pass the state exam fail the state part, and so that's why I really want to emphasize that. So you've got two questions on disciplinary action. What can the Real Estate Commission do to licensees? So let's go to your Appendix A, and let me show you where this would begin, and maybe on the bottom of page 617, bottom right. While we're here, let's just talk about the commission for a tiny bit. The Real Estate Commission is comprised of 9 members. These 9 members, everybody, are appointees. They are not employees of the Real Estate Commission. Yes, if you call down to the Real Estate Commission, the headquarters in Raleigh, there are lots of employees there, but when we talk about the commission, the panel that reviews complaints, etc., looks at license applications, that is 9 people. 9 people. You do get questions on this from time to time, and in your take-home work, that test, the pre-sample exam, has a lot of questions in there about license law. That's why I picked it. I thought it'd be so good for you. 7 members are appointed by the governor, and then 2 of the members come through the General Assembly. So 7 appointed by the governor, 2 come through the General Assembly, 1 coming through the Senate, and 1 coming through the House of Representatives. And you do need to know that.
Say it one more time, please.
How about on page 617? That's where I am, 617, bottom right. Real Estate Commission. At least 3 of the members have to be licensed brokers, At least 2 of the members are people without a license and without any affiliation in the real estate business. Remind yourself, and it reminds you here in the reading, that the Real Estate Commission is there. One of their roles is to protect the general overall public. Protect the public by overseeing licensees. Protect the public by the education programs that we have to teach and you have to take. So one of their main jobs is to oversee and protect the public. Now, if you're asked what does that mean, overseeing licensees, we're going to look at some of the things they can discipline you on, but they really don't tell you how to do your business. The Real Estate Commission isn't going to say, you got to work 40 hours a week. They're not going to say, show up at 8 and leave at 6. And by the way, the real estate company you work for can't tell you that either. Everybody with me? Because when you go to work at a real estate company, you're what we call an independent contractor. You do your business paradigm or model the way you want to. Now, your BIC would have a right to say, hadn't seen you lately, or what you working on. You know, they do have a right to oversee and make sure, do you need any help? They want you working if you're going to be working there, obviously, but they can't say show up at this time and leave at that time, because then they're treating you like an employee, and then they would have to take tax out and pay, the workers' comp and Social Security and all of that. These members serve 3-year terms. Now, I want you to write this word down. It's not in your reading, but I'm going to give you the word in case you see it. They serve 3-year staggered terms. Staggered terms means the whole commission is not replaced every 3 years. Staggered terms means if Ian got appointed, his 3 years would start. Jose might be leaving next year. You know, it's staggered. So there's always some continuity on the commission. So 3-year staggered terms. And the governor can replace someone that might need to be replaced, but it is an appointment. So you could say it's an honor to be appointed to be on the Real Estate Commission. They elect a chairman of their amongst themselves. They don't get salary, but they do get, old-timey word would be room and board, stipend for food and travel, that sort of thing. They meet once a month unless there's some other reason they would have to meet. So look at the bottom of page 617, bottom right. So we know this is how we get our license, by going through the Real Estate Commission. They wrote this program. They dictate that we have 75 hours together, 3 of which is the exam. So remember, I mentioned to you that we're going to have our hours in. So it's 75 hours, 3 of which is the exam. So 72 hours of lecture. And post-licensing, pre-licensing, and they even oversee continuing education. They write and rewrite the general update course every year. So the update course is a 4-hour course that when you're taking CE, it's one of the CE courses you have to take in order to keep your license active. Top of the next page, top left, I would remember that the Real Estate Commission, look at the first paragraph, it should be noted the commission is prohibited from regulating commissions and fees charged by the licensee. So remember, you learned in Unit 7 that the Real Estate Commission is negotiable in every instance. Didn't you remember that? The Real Estate Commission is not going to dictate what rates of commission. I'm on page 618, top left. Everybody there? Okay. So let's also add this. If you were to have a complaint filed against you and the Real Estate Commission is looking at that, they are not going to issue you a fine. Remember, they don't monetarily fine licensees if there's a disciplinary reason. What they can do to you and me would be suspend your license, revoke your license, censor, and reprimand, right? So when we said censor is that public telling in the real estate bulletin that comes out about every 2 months, here's what this person did, here's their name, here's what happened to them, and here's where they worked. And so that's a public censor. They can reprimand by putting a note on your record. They can suspend for a certain amount of time. They can revoke your license or even permanently revoke. A licensee can willingly turn in their license too. It's kind of like, it reminds me when you go to court or watch these Law and Order kind of shows, the person who's charged with something agrees to take the plea and they say, I'm guilty, but I'm taking this. So you do have a right to do that, just turn in your license. I want you to take a moment on page 618. Do you see where you see your very important point and disciplinary authority? Take a few minutes and read that little section there, down to prohibited acts by licensee. So there's a lot in that one little section, everybody. The terminology injunctive relief, does that make sense to you? It seems like that terminology came up in Unit 6 when Yasmin taught you about zoning and restrictive covenants. Didn't a term come up called latches? If you live in a neighborhood that has restrictive covenants and somebody is violating a covenant, that anyone in that neighborhood can approach that person and say, you're violating a restrictive covenant here, because what you want to add on to that is, and it could affect the value of everybody's property, right? And if that person continues to violate, that person or anybody in that community can go to court to seek an injunction. And an injunction means stop what you're doing. And so the Real Estate Commission can seek injunctions through courts. So they technically, they oversee licensees. And so if someone's acting like a licensee without a license, technically the commission wouldn't oversee them, but they can proceed and seek court assistance asking for an injunction. They're acting like a real estate agent without a license. Comments? So disciplinary, prohibited acts by the licensee. If you misrepresent, now on page 618 and 619, and in fact the examples go over a little tiny bit over to page 622. We're not going to read over all these examples. We don't have time to do that in class, but I highly, highly, highly recommend that you read these examples. You do have a couple of test questions, even in maybe one in your license law section, about material fact and misrepresentation or omission. The sample test that you all are going to do tonight has a couple of questions on that too. So I know part of the grayness about it is it negligent or is it willful? And so reading through here, maybe it'll help clear that up for you. Basically, willful means you are aware, you know it, and you did it anyway. You either told a lie about a material fact or you left it out, which would be omission. Negligence could be you knew, but you made a mistake. You transposed numbers, you just forgot. Could be something like that. But negligence oftentimes is you did not know. And even if it says the agent did not know, the commission may look at it and say, but you should have known. Shouldn't we know about highways coming through? Shouldn't we know if the tax rates are getting ready to change? Guys, those are things that you should know. And so the commission, if a complaint is filed against you, they'll look at it. Did you know or should you have known? Or is this something that is not something we expect out of a real estate broker? So this section here about misrepresentation of material facts is the number 2 disciplinary reason that licensees become disciplined, by misrepresenting the property, saying things that are not true. I don't know if the puffing crossed the line, where you're over-exaggerating and the consumer counts on you. Even something, this might sound simple, but it really isn't in the whole scheme of things, saying that the countertops in the kitchen are granite when they're not granite. That would be, that might be willful, or a commission can say maybe it's negligent. It feels pretty willful to me. Now, if you don't know what something is, don't say something. That's the biggest challenge, I think, really in real life. We want to answer all those questions because the consumer came to us as the expert. It's way better to be humble and say, let me look it up. I don't know if that's granite, and I can't tell. Guys, I don't know. I mean, if you've ever bought granite, you can tell, but lots of us don't know the difference and what kind of solid surface that is, so you really need to be careful about what you say, and don't just kind of wing it, because that will get you in trouble. The number 1 violation through the Real Estate Commission is trust account violation, where the trust account either doesn't reconcile, monies are missing, or monies are not accounted for, and it's a real bookkeeper's job. And it does not necessarily mean that real estate brokers are stealing money. Guys, I doubt that even comes up hardly at all. It really is the bookkeeping of it and all of the numbers matching up and reconciling, and that's the broker in charge's responsibility to oversee it if the company has a trust account. There is not a commission rule that you have to have a trust account. When I say you, I mean the firm. There's no rule saying the firm has to have a trust account. The rule is, if you are collecting monies of others, yes, you do have to have a trust account.
Can you run interest on that? Because I have a...
Well, yes, you can run interest on
What
that.
happened to the interest?
What happens to the interest, these trust accounts can be interest bearing, and the interest would have to be made of, the parties would have to agree where the interest goes. And in our sales contract, it literally says, and by the way, let me remind you again, read that sales contract. The sales contract literally says it'll be an interest-bearing account, and the broker's firm will keep the interest, the listing agent's firm, whoever has the escrow account, will keep the interest for the maintenance of the account. So I believe Yasmin might have told you, and maybe we even talked about it a little, most companies are not handling trust accounts anymore because it is a serious bookkeeping challenge. And so a lot of these firms, even the larger firms, are choosing to have the closing attorney accept the earnest money deposit instead of the listing firm who traditionally has always taken it. Since we're talking about that for a minute, because I want to move on with a disciplinary, since we're talking about that, and a lot of this is review, everybody, because we have talked about it before, as a provisional broker, if you receive an earnest money deposit check on a listing that you have, offer comes in with an earnest money deposit check. If your company is handling the trust account, you give it to the BIC immediately. So don't overthink that question. If you get a question, PB, what do you do with earnest money? Give it to your BIC immediately. That's the answer to the question, right? You don't need to be holding on to it. However, can't you hold on to the due diligence fee? Didn't we say if the buyer writes a check for that, you can keep it paperclip to your file until that offer ripens into a contract, and then what do you do with it?
Hand it over.
Hand it over to whom?
So,
Seller, because it's written out to the seller.
What if you were brokers and you start to turn it into the, broker?
Technically not. Hamad's question is, what if you're a non-provisional broker? Do you have to give it to your BIC immediately? Technically not. But the BIC is the one who's responsible for getting it deposited, right? So the question's going to be more about PB. But once you reach your broker status, your full broker status, you have more, you're more responsible for yourself. And so you should be able to hold on to an earnest money deposit check without losing it. But most firms probably have policy, give it to the BIC immediately anyway, because they're the ones who have to account for it. Alrighty, so here's a little section about disciplinary, that the commission can suspend, revoke, reprimand if you have misrepresented a material fact or omitted it. And I really think it will behoove you to read some of these examples that will help. Go with me over to page 622. We're looking at disciplinary actions. Conflict of interest. Are you with me? Left-hand column. Undisclosed dual agency is majorly conflicting. Why is that conflicting? Why is that a conflict of interest?
but you cannot tell,
Privately representing two people.
Say,
I said because you're privately representing two people on like opposite sides.
because you're privately, which means what?
It's undisclosed.
It's undisclosed, you didn't get their permission. Remember, agency has to be with written informed consent, eventually, right? And so this undisclosed dual agency, probably you're acting like you're trying to help. Let me give an example. You're trying to help a buyer. Like, I think the seller will take $5,000 less when you're really not a buyer's agent. You really are a seller sub-agent, and that looks like dual agency, undisclosed, like you're trying to help them. And so what Portia said, you're acting kind of privately secretive about it, and agency has to be discussed openly, doesn't it? It's informed written consent. Now, you will be asked about your agency, a lot of questions about agency, everyone. And in this Appendix A, there's a lot of agency license law too, coincidentally, which if you go back and look at Unit 7, there's a whole bunch in Unit 8 in there. But agency would have to be disclosed when? When do we discuss agency?
The point of first substantial contact.
The point of first substantial contact. So you do need to know what is first substantial contact. And first substantial contact is when the conversation begins to change or shift from facts about the property to something more personal, motivational, confidential, financial about the party that you're meeting. And so the commission says no later than first substantial. Does that mean that I can talk about it as soon as I want to? Yes, and I probably would. Why not just go ahead and get that out of the way instead of it happening when the cat's out of the bag? You know, oops, you told me something confidential. Now I got to tell you not to tell me something confidential. I mean, it seems kind of funny, doesn't it? But that is the point of no return, if you will. No later than first substantial. So this undisclosed dual agency, guys, that all should have been discussed no later than first substantial. You do not act for someone without their informed written consent, and you do not act for both parties unless both parties have given you informed written consent. Now, having said that, I'm really saying written a lot, aren't I? But didn't you learn that some agency can be created verbally? But don't we know it has to be in writing eventually? No later than the writing of the first offer, no later than the presentation of the first offer. So what I'm alluding to, and I'm gonna take you there, but I'm gonna remind you to read it. And this is in Unit 8, and let me show you, because you need to look at this. Or maybe 7, let me look real quick. Page 163, just go, hold your place and go there. 163 and 164, you've got 3 different situation examples. It would be highly recommended that you go back and read these examples, because it is talking about dual agency and when the scenarios and when it needs to be put in writing. Any questions on that? So if you violate agency law, which really is the law, isn't it? And it's license law too, then commission can discipline you. So that would be a conflict of interest. Now, back to page 622, right-hand column, self-dealing, where you're making a secret profit or putting yourself ahead of the client, that is a reason to be disciplined. Representing another broker without consent. Consent from whom? No. Your BIC. Representing another broker without consent from your BIC. Guys, you work for one BIC at a time. Let's just leave it there. You work for one BIC at a time. It would be real unusual to have another broker in charge. But I can think of a couple of times, one, I can give you an example. I've got a friend who has a license here in North Carolina. She's got a retirement home in Virginia, and so she's going to work some in the mountains in Virginia. And she's going to work some selling real estate in that area when she's up there, and she's going to work some down here selling real estate. Now, she would have to have a BIC at each location, but as long as both BICs give consent, it's okay, but that's very extenuating. You and I don't have more than one BIC. In other words, your BIC, if you said, I want to do property management also and go to work for a property management company, now I'm just thinking out loud, your BIC might say you need to choose what you want to do, because that's 2 different businesses. Everybody understands that, don't you? When you're in residential brokerage, managing property is a whole different field, everybody. I'm not saying you can't do it. I wouldn't do it. And I've been doing real estate forever. I wouldn't do it. And I don't know that your BIC would want you to do that, because then that means the BIC needs to know everything about property management, right? And making sure that they're following the guidelines. All righty, improper commission. So paying commission to someone who does not have a license would be improper, wouldn't it? So is that a good enough answer? It would be improper to pay somebody a commission if they don't have a license.
Correct.
That's a correct answer. Might not be the best answer. Let me give you a better answer. It would be improper to pay anyone a commission, meaning even a referral fee, unless they have a license on active status. So someone could have a license that they never activated. And the way we activate it is to go to work for a BIC, and the BIC will send in the forms to the commission that they are supervising us. So is everybody good on that?
So you can get referral fees if you have a license, active license?
No.
No?
Active license, yes. Is that what you said?
Yeah.
What's your question again?
Because
Ask
that's what
your-
I remember, you cannot be given any bird dogs or any
You
fees to
can.
anybody that refer you a customer.
If they don't have a real estate license on active
But if they
status.
have an active license, they do, they
Mhm.
can, okay. That's what I was saying, thank you.
Okay, I get what the question is. The question is, how do they word, if they say, can you pay a bird dog fee to Mary Jane? That question, the answer is no. It's not, they didn't give us enough information, so we'll say no. Can you pay a bird dog fee, finder's fee, referral fee to Mary Jane if she has a real estate license? Well, I don't know. Is it active or not? Right? Can you pay Mary Jane a bird dog referral fee, finder's fee, if she has a license on active status? Yes, you can. That would be the key. Good question, though. Hey, that sounds like a real getting detailed question. Alrighty, so here we are looking at the disciplinary areas. Page 623, look at your left column, very important point. Why don't you take a minute and read that little paragraph? Left-hand column, very important point. And does that make sense? So when you go to work for a real estate company, all monies run through the company. If you get a listing and it sells, the commission will run through your firm. The firm will pay the individual brokers or PBs, right? Okay. In other words, while you're on PB status, you would never be allowed to accept commission from another source. Technically, when you reach full broker, the rules change a little tiny bit, but let's just keep it simple right now. Money's run through the firm, and the firm, are they going to get a cut of everything that you do? Well, it wouldn't be sense to have it backwards where you get the money and then you give them the cut. It runs through them because you work under their name, don't you? Alrighty, and unworthy or incompetent, guys, that's really, I don't want to make it sound like it's not serious, because it is, but it's almost like a catch-all little section. Unworthy, incompetent could be not knowing how to fill in the forms correctly, right? And for example, one of my students owns a company now, and she called me one day, and I may have mentioned this to you, and I'll tell it quick. She called me one day and said one of her agents got an offer on one of their listings, and the offer came in on outdated forms. Well, the outdated forms should be not even available. They should have been shredded. They're not online anywhere anymore, but an outdated offer to purchase. Guys, an outdated offer to purchase is way outdated because it changed completely when it changed. The one we have changed completely. She said, we don't know what to do with that. And I reminded her of a little rule. License rule says all offers must be presented immediately, no later than 5 days. Isn't that right? Mm-hmm. And she said, I know that, and we talked about that we need to present it. And that's true. Even on forms that are not proper. And I said, you know what, but I don't like that either. You know, did you ask that agent to resubmit the offer on the proper forms? And the student of mine says, yes, we did, and she refused. Now, everyone, that's not good. And so, anyways, I said, you know what? We know you have to present all offers. I said, let me get back with you. So I called the real estate commission, and first thing, you present all offers. However, when you present it to the seller, ask the seller what they want you to do. Because isn't the seller the boss? Ask the seller, do you want to negotiate with this, and it's on the wrong forms, and we don't do a lot of the things that are on here now, or do you want me to tell them to resubmit on the proper forms? Now that makes real good sense, doesn't it? Let the seller tell you what to do. Now, somebody could have complained to the real estate commission that appears to be incompetent, doesn't it? Seems to me. If you're using realtor forms, you need to use the most recent ones. Alrighty, improper dealing, if you look in your right-hand column on page 623, couple examples in there. Let's look at a couple of these examples for a moment on 623. Look at your first two examples, right-hand column.
in jail already.
You hear about real estate jail, don't you? So that would be improper. Now, everyone, in your closing unit, it doesn't say that real estate agents conduct closings. It's not advised, but it doesn't say you can't do it. You're not going to do it. I mean, that's not going to happen. But think about it. What if the transaction was a cash transaction? You know, or what if it was something, loan assumption? In the olden days, agents would do some of that. Not often, though. And so you, with things like they are now, with the loan and the TRID and the Dodd-Frank and all the forms, you will not want that kind of liability and responsibility. Closings are conducted an attorney-approved state at a lawyer's office, aren't they, usually? All righty. Disciplinary practices, go to the left-hand column, 624. Some other things. Real estate licensees may not perform certain things like drafting legal documents. We know this, don't we? You may not abstract an opinion of title. Who does that? Attorney. You may not provide any kind of legal advice. Now, Monday when we were talking about capital gains, I even said to you, I would be careful how I would say to someone, you need to get tax advice. The capital gains laws have changed over the years, but we just don't want to get outside of our realm of expertise. So we don't give legal, financial, tax kind of advice. Violating any commission rule would be, what did we say? It's a misdemeanor, isn't it? To violate any commission rule. Look at the bottom left, other prohibited acts. So this is the section where you could get a couple of questions, everybody, what we've been talking about. And so you got your license by lying, not telling the truth on your application, where you were convicted, pled guilty, or no contest. And if it's a moral turpitude, the commission is looking for character issues, aren't they? I often have students come to me and ask me, they're embarrassed about it, but they'll come and say, Jan, I've got something on my background check, maybe a DUI or something when I was younger. Do you think the commission won't give me a license? And everyone, they don't tell us what they're going to do. They look at each person individually. They may say, come see us. Come down to Raleigh and talk to us about that. Because they're looking for character issues, aren't they? All righty. Look at your exam outline. North Carolina Real Estate Authority and Purpose. We've already talked about that, didn't we? Are y'all with me? Looking at your outline. Requirements for an active license. Let me show you where that is in the book. And this is our first day lecture. And let me show you, reminding you about that. Requirements for an active real estate license. Hold your place, or you can just go to page 670. So let's remind ourselves about this new licensee information. When you get your license, well, let's start at the beginning, everybody. By now, I hope most of you have ordered your criminal background check. Someone brought to my attention that there was a misunderstanding about when you needed that. Guys, you need your background check in order to apply to the Real Estate Commission to take the state exam. So it would be linked up with your real estate application. So it would be advisable to go online to where they go online to your application. And you can you can set your name up, by the way that it's going to be on your ID, your full legal name. You're going to open up your application, and there will be a link to the criminal background resource area they want you to go to, that you can just link it to your application. And you won't necessarily get the report, but you should get word back that it was done, and it will link to your application. And it should only take a few days, But Renee told me that hers took a couple of weeks because she lived in a couple of places and also got married or had a name change. And so guys, if you haven't done that, I would go ahead and get it so that's not hanging over you. Once you finish this course successfully, you want to finish the application and hit send, hopefully the day we call you and tell you you passed. Because the sooner the commission has it, the sooner they can get back to you and say you're eligible to schedule your state exam. So it passes through them before you can schedule the exam at the testing center. And the real estate commission will email you. You're eligible to schedule your state exam. If your criminal background check's not there, they're not going to even process it.
What's the name of the website one more time?
Let me show you where it is. It's on page 650. But I believe if you open your application, it'll be there too, Hamad. That's what I would do.
I didn't do anything yet.
Okay.
Thank you.
And your the application, online application process begins on 6/46. Now, when you schedule your exam and you pass the state exam, both parts, actually the exam that you're going to be taking after you're here is called the licensing exam. And it'll be national, it'll be state, two-part exam. You'll get your grade after you finish both parts. And so you'll be given 2.5 hours to take the national portion. You'll be given an hour and a half to take the state portion. And so after you're finished, they'll let you know if you pass both parts or which part you pass. And let's just presume you pass. When you pass this exam, they will notify the real estate commission that you passed. And the commission will once again look over your application to review it. If everything is satisfactory, they will send you in the mail your license certificate. It'll be 8.5 by 11. They'll send that to you in the mail. It's got the date of your license issuance on it. That's the only place you'll see your license date. That license date is important for what? Not paying your fee, it's for
No, it's for that.
what education? Post. Post-ed is tied to your license date. So you've got 1 year to get at least one 30-hour. You've got your second year to get your second 30-hour. And your third year to get your third 30-hour. So we're finishing October 29th. Let's say you get your license November the 10th. So November the 10th next year, you would have to have at least one of your 30-hour posts. November 10th of the following year, second one, and November 10th of the third year, your third one. Most students take on pretty quickly, so they don't have this hanging over their heads. This all is contingent on if you want an active license, though. If you don't want an active license, technically, you don't have to take your education, but sure as the world, you'll want to activate that license one day, and the commission's going to say, get all of your education now before we even activate you. And that will be a mess for you, because if you want to activate it, there's a reason, like you got a job offer that you couldn't refuse. And now you got to go find all the courses that you need. That would take some time, wouldn't it? What's your question?
Well, regarding those classes, are they longer than 4 hours? normally?
They're
Like-
30 hours.
No, I know, but daily, can you do like 8 hours a day or still 4 hours, 4 hours?
My classes are 7.5 hours a day. Most of my students, so far anyway, want to get it knocked out in 4 days. And so we meet 2 days for 2 weeks. So the way that we've taught it this year is Tuesday, Friday, 9 to 5:30 for 2 weeks. And then we do run a Saturday, Sunday class 2 weekends. Now, I am getting some input, and we used to do this when I first opened the school. We used to offer some at night. where we would have 4-hour courses. And a lot of students like to come at night, but then guys, that's gonna take 8 meetings. And so, it's kind of, do you wanna come more or come a whole lot of time and get it done? But really and truly, taking it in 4-hour increments is kind of good, because once you start working, giving up 2 days is kind of tough too. Because usually it's really cute. Even the new licensees that are taking their posts, they're on the phone doing business and working hard. So, but you got to do it if you want your license to use your license. So we're looking at offering half a day and some evening classes too. I've got an instructor I'm getting ready to interview who would prefer to teach in 4-hour increments.
Do those require like testing? and stuff
Yes,
like
sir.
that too?
There's a test at the end of the course. There's not another state exam. So you do have to pass the end of course exam.
So if you fail it, you just take the class again?
I haven't had anybody fail, but cause it's not that it's easy per se, but we've got 30 hours to talk about units 7 and 8. It'll be a different book, but we're gonna talk about agency in one of those. We've got 30 hours to talk about sales contracts and closings. And we spent a couple of days on it. I mean, a couple of 10, 11, 12 hours on it. So it should be a review, most of the courses. Alrighty then. And so to keep your license active, we know we take the post. And there's continuing ed. This is a test question area, guys. This is the commission expects you to know about your license. Continuing ed, let me just tell you how it's worded, and I know you wrote it down early on. The new licensee would need their first continuing ed. When we say first continuing ed, we mean 8 hours. 4 hours of update and 4 hours of an elective course. You need your first continuing ed before your second renewal year, June 10th. So let's say you get your license November 10th, 2018. When will your license renew? When will it expire if you don't renew it?
November 11th, next year.
June 30th, 2019. Guys, you need to know this stuff. Your license will expire if you don't renew it by June 30th of 2019. Guys, we've talked about June 30th a lot, but it's all a whole bunch right now, isn't it? So you need to renew your license before midnight of June 30th of every year. So you don't need CE before then, because you just were here, right? You need your first CE before June 10th of 2020 if you want your license active. So your first CE is due before your second renewal year, June 10th.
Gotcha.
Got it? Okay. And that renewal information's on the bottom of 671. The post license and continuing ed is on 672 and it's on 673. So you got questions about that. Let's go back into the body of the license law, Appendix A. And if you'll go with me to page 616, let me just bring this up and we'll take a quick break. Page 616, please. You will have a question about what can an unlicensed assistant do. So on page 616 at the bottom right, you've got permitted activities for an unlicensed assistant or employee. And so I would read the left column on page 617, all the things that they can do. Now, I'm not trying to play this down or be disrespectful, but it's a clerical administrative job, everybody. They cannot act like a broker without an active broker's license. So they can be your assistant, literally an admin. They can put signs up, sure. They can type up things maybe and put what does it say? I don't want to say anything wrong. Submit listings, that's what I mean. They can put things into MLS, they can receive phone calls, forward them, they can put signs up, they can order and even supervise any kind of an inspection. You know, so there are things that they can do that wouldn't be a violation. Probably you don't want them having much of a conversation with any of your clients and customers, because clients and customers want to ask real estate things, and that it could put the assistant in a bad spot. So forwarding a call to you would be better, wouldn't it? And so having said that, you don't want someone unlicensed at an open house. So unlicensed assistant may not host an open house. It needs a licensee to do that. And I can tell you, and we're not going to dwell on it, but I've had real estate brokers argue me down on that in a continuing ed course when we talk about it, and guys, they're not licensed. Now, I don't know, and this isn't the reason I don't believe, but if you think about the Real Estate Commission protecting the public, what about the seller? What about the seller? If you send somebody to conduct an open house that doesn't have a license, how are you representing your seller? Not very well. And the argument that I've heard is, well, my question would be, well, what if that person who walks in on the open house says, hey, I love this house, I want to make an offer. And that person there doesn't have a license, then what? Well, they'll call me. Really? Really?
I'm sure the seller will be like, are you scared of me?
Are you serious about that? Because people lose patience, don't they? They expect more out of us than that. And so no, need a license to host an open house. So I would read over that and look at your exemptions too. So at the bottom of the page are some exemptions, meaning people who don't need a real estate license. And didn't we say for sell by owners don't need a license to do that, or buying their own homes? Didn't we say lawyers? Didn't we say trustees? Attorneys, in fact, would be like a power of attorney. And didn't we say if you are an employee of a company that is managing their own property, you can go show that and do that job if it's part of your job? Look with me on your right-hand column, top right, number 6. Take a minute and read that. So you read in Unit 11, or maybe Chris brought it up, when you work for a property manager, you can, if part of your job, you can go show those rental units, can't you? If it's part of your job, your employee. You, however, cannot negotiate. And he also talked to you about the Vacation Rental Act, I believe. And under a Vacation Rental Act, as an employee, you can go show that vacation rental and you can quote a pre-negotiated price. Did he talk about that? Let me just say it a different way. If you work at, if you're an employee at a vacation rental company and somebody wants to look at the house at the beach because they're thinking about coming down next summer for a week, you are allowed to go show that without a license, right? If your manager said, we want $1,500 for that week, but if they say, if they'll say, I'll give you 14, I give you permission to quote 1,400. You can do that. That's not negotiating. But in a residential area like us, you're not even allowed to do that one step. Everybody good on that? All right, let's take a quick break and we'll come back and finish with our outline review.